So, welcome. Thank you all for being here. If you didn't see me yesterday, I'll redo my introduction. So, Rob Houle, Natsikasun, Wapsusipi, Tano Chinia. My name is Rob Houle. I am from Swan River First Nation. I am a 3L here at Thompson Rivers University. I got fandangled into doing this because Murray asked me, and I like to talk a lot, so it seemed like a natural fit. I think for me, I'm very grateful to be here in Kamloops and studying law in the traditional territory of the Kamloops to Secwépemc, which has been very welcoming. And I know we have elders and esteemed guests here tonight. But I think just to get things kind of started, I wanted to give the Mooters a chance to kind of take a deep breath. It's over. As I said last year, I was in the Moot as well, and I know how stressful it can be. So take a second, take a deep breath for yourself, and I think give yourself a round of applause as well, because you deserve it, because a lot of work goes into this work. And like I said before, they call it a non-adversarial moot, and it's about negotiation and relationship building, but the conversations can get very adversarial and very heated if a button gets touched, or you come to a loggerheads and you can't get around an issue, which might have happened a couple of times last year at the table that I was sitting at. But I think it's also very taxing when you have to start to think about how you're going to come to a final agreement, how you're going to negotiate, how you're going to open doors, and how you're going to work together to get to a final outcome. And that is very mentally straining. So I commend you all for being here, for making it through, for having the wherewithal to come to an agreement, those of you that did, and those of you that didn't, well, you didn't fail, you didn't do anything wrong, because that's where a lot of these relationships in Canada have been and are going to continue to go until we can start to get on the right page in terms of resource extraction and things like that. So I'm asked just to share a couple moments here about what's the purpose of the dinner, what's the evening going to look like. So we're going to have a dinner, we're going to have a couple of speakers later on, and then we're going to have some entertainment, and then we're going to wrap up at about 10 p.m., the agenda says. But I think when you come together and you start to have some of these conversations and build these relationships, it's always good to send people off on the right note. And in Indigenous communities, especially in where I come from, the Cree community up north in the wintertime and things like that, visiting is a very important kind of activity. You welcome people into your house, you welcome people into your territory, you sit with them, you have a wholesome meal with them, and you make sure before you send them off that they're leaving with a full belly and a full spirit, and they're heading home in the right way. So I think that's what we wanted to do here for this banquet this evening, because understanding and building relationships is key to how we move together as nations and as communities. And you do that by working together, by sharing meals, by sharing a space, by shaking hands, by saying hello, by doing all those usually trivial things that actually build up into a very rewarding kind of relationship and sharing of resources and lands, things like that, stories. And one of the key parts of building that relationship is coming to that kind of mutual understanding and making sure everyone's on even keel and on the same page. And I told this story in one of the law classes, I think last year or this semester, but I used to work for an organization in Edmonton, the Treaty 6 Confederacy, which is very much focused on protecting treaty rights, focusing on treaty rights and treaty issues. And we worked a lot with elders, and in the years before I had joined the organization, they were kind of involved in a very contentious Indigenous rights, treaty rights conversation. And there was an issue at trial around how the treaty negotiations went and who was negotiating them and what kind of conversations they were happening. And if you're not familiar with the Cree language, there's an old Cree and there's a new Cree. So the old Cree has a very unique words. Words have a different meaning. And then when kind of colonization and things started to happen, this new kind of language started to develop, a new kind of essence of Cree. So one of the most important leaders in Treaty 6 history and Treaty 8 history as well is a leader by the name of Mustas. And Mustas, if you're familiar with New Cree, and if you've spoken any New Cree, you'll probably think I'm talking about a cow. But actually, in the old Cree, it was actually what we called the buffalo before contact and colonization happened. So they were at trial. This elder was on the stand. They went through a day of questioning. They asked him to come back the next day. So he was on the stand for about a day and a half now, and they had a translator in the class in the courtroom, and he was a new Cree speaker. So as the elder is going through telling this story about his ancestor Mustas, the negotiations, and how those conversations and negotiations went, he was referring to his elder, his leader Mustas, talking about Mustas and the conversations he was having, the negotiations, what they were demanding, and then the translator stood up and he said, what he was saying was that my grandfather, the cow, was saying, and at that point the elder froze up, face went straight, and he got very upset, and they had to take a recess in the court because he had taken that translator aside and he had spoken at the top of his lungs, the Moya, Mustas cow, Mustas buffalo. So then they had to go back and change the court transcript and change how they were translating it because he had to correct this understanding. Because if you don't come to the right understanding, you don't have the right people having the negotiations, and you don't have the right outcome at the end of the day. So that's a little bit of a history story and a history lesson that I like to share. So my understanding is that we're going into dinner, and we were kind of conflicted on how we're going to try to figure out what the dinner is going to look like. So I think me and Murray, if there's any qualms, you can blame me and Murray. We're going to start at the back of the rooms, the last table. Feel free to get up, grab your plate, go to the buffet, and then we'll head after that into the keynote address, which will be about 8 o'clock. So thank you very much for being here. Take a deep breath and enjoy your evening. I see a lot of wine still on the tables as well. So we're going to go back into the agenda now, heading into some of our keynote addresses. So I would like to welcome to the stage true alumni from the inaugural class, Ms. Christy Stewart. She's a partner at Stewart Springford, and she took part in the Kawaskimhon Moot 11 years ago.
Wake, bonsoir, and good evening. As you've heard, my name is Christy Stewart, and as most of us tonight, I have several roles over the past few days. It is really quite an honor to have been invited to address you tonight, and I hope I do okay. The light is a little bright and my glasses are a little dirty, so I've got a bit of a glare going on. I would first, of course, like to acknowledge the Honorable Len Marchand. I would also like to acknowledge Judges Linda Thomas and Raymond Phillip with us tonight. What a pleasure it is to be able to say that they are all beloved Indigenous judges. I would also like to acknowledge the elders that we have with us, and I'm going to do my best to say their name correctly. We have Elder Viola Thomas, who also goes by Animki Wedam. Thank you. And we have the pleasure of having a Métis elder with us as well, and her name is La Bocan. At this time, I would also like to recognize the territory that we are on, to Kamloops to Secwépemc. It has really been a pleasure to be able to welcome you to the territory as a member of Kamloops to Secwépemc myself. And I'd like to talk a little bit about the territory and the experience that you've had here. I want to acknowledge that all of you have been welcome guests. We have been waiting for you. We have been planning for you. And by we, I mean Murray has been planning. I would be remiss if I don't acknowledge our Member of Parliament and I'm not sure what you would call him, a colleague, a fellow classmate of Kamloops Senior Secondary. Him and I went to high school together. Frank Caputo is here with us. And then finally, Dean Millard. She is lovely, as you all know. Thank you. It was about this time of year when Murray Schulte and I, the co-coaches of the Kawaskimhon Moot, were at the University of Victoria campus last year, and Murray said to me, I think we can do this. And I said, I think it's time. And we texted the dean and said, we should host the Moot. And as fast as she could type, she said, absolutely, yes, we will do that. I am not convinced that she had been to this Moot before or understood the national scope of it. But her vision remains strong, and we are so grateful to you for holding on to that vision and recognizing the importance of advancing this type of Indigenous knowledge and Indigenous education and giving the opportunity to all of these students to be here tonight. Thank you. You were all invited to this territory to learn, to grow, and to create a law school memory that I would expect is going to stay with you for the rest of your lives. As it's been acknowledged, I was a member of the 4-person team that was the first Moot that TRU Law participated in back in 2013. As I'm sure you're all gathering an appreciation for, precedent is a big deal in law, and we had the opportunity to not only be the first class to build a law school in 2011, and I'm wearing the pin they gave me on that day, just to commemorate that, because like I say, it's not often that we get to kind of push ourselves into history that way. So it is such a pleasure to be here on the 30th anniversary of this Moot and the 10th anniversary of the graduating class of this year, of which, like I say, there's a few alumni here. So we didn't think we could do it back then, but look at us now, hey? I thought the music was starting. I thought I'd been cut off already. Let me put my glasses on here. I wanted to pick up a little bit on what Dean Millard had said in the opening comments, that the students that participated in this Moot are the agents of change. And I know that that is such a momentous ask of you, that you will be considering your careers going forward, knowing that you would possibly change the world. It seems like a lot. I appreciate it. And I'm going to say that I don't think that you could do it unless you had some very keen coaches and some very great mentors. So I really want to give a lot of credit to the coaches that are here. I am one of those coaches. Like I say, Murray's another one of those coaches. And I wanted you to know that we suffer as well with you along, as you're going through this process. It is very terrifying for us when we say to you, what jurisdiction are you talking about? And you blankly stare back at us. And then it is such an honor and privilege when you know what you're talking about when we finally get to the Moot. And that really makes all of that worthwhile. I know that some of the coaches are paid, a lot of the coaches are volunteers, but at that point it really doesn't matter. We are all so proud of you. I know that we're proud of our team. I know that the other coaches are proud of their teams as well. So good work, you guys. Thank you. I want to talk a little bit about the territory. I heard some students remark on the family of deer that we have going around on campus. They truly are our pets. The animals have never left. They've never left this territory. It is their territory, and they make it known to us. And it was fun to hear some students remark on how exciting it was to see the deer. So if you haven't kind of looked around, I suppose, in the territory or done some of the research, the reason that Kamloops is named Kamloops is because it's a meeting of the waters. There's two significant rivers that cause that kind of confluence. One is, they're from opposite directions, which I think is quite interesting, particularly in a legal context like this. We have the North Thompson River. The North Thompson is very strong, it is very long, it is very deep, it is a little bit dangerous. And then we have the South Thompson River, which is slightly more gentle. It's a little bit more shallow. That's where you will see more of the floaters kind of, come, on their inner tubes, that kind of thing. But nonetheless, they meet in Kamloops. And I want you to think about that as you reflect on this experience that you've had here, about if you came here thinking that you were going to have an adversarial mood and you're going to leave with a friend, for example. How many different ways have we converged? I happened to notice that the Honorable Len Marchand was wearing his engineering ring. And I wonder, how does a chemical engineer make his way to be the Chief Justice of British Columbia? And what that convergence, when that convergence happened. It's not a challenge that you have to tell us that story. I was just kind of curious about that and think about the intersections that each of you have had in order to get here today. I also wanted to note that we have two very tall sacred mountains that overlook that convergence. We have Mount Peter and Mount Paul. And, they offer a different perspective if you're up that high as to where people are traveling on these rivers. The other thing that I wanted to say about the South Thompson, while it may seem like it is a less than river, it is a river that is the highway for the largest concentration of freshwater salmon to make their way up to the Adams Lake watershed. Now, I would like to premise those comments by saying that I am a lawyer, I'm not an ecologist, so if you want to challenge that, you can, but that's my understanding, is that it is a significant river for that reason. And then the final thing I wanted to bring to your attention is that this is ultimately the territory of the coyote. Now, the coyote's kind of a tricky guy. He's known as the trickster, and he's a bit of a center point for education and for learning because he causes you to consider things that you may not have known to be true before. He tricks you into learning things that you thought were, as they were, turn out to be something different. And as you guys will, progress in your legal careers, I think you will gain a great understanding of what the coyote kind of does in the background to help you understand this. I'm looking at the judges as they're smiling. I think they understand exactly what I'm talking about. So again, anyway, I'm just thinking as you reflect on this time, as certainly I have, as Marty talked about at the closing ceremonies, that this moot has never left her in her legal career. She thinks about it quite often. And I hope that you have had a really good time here. I hope that this territory has looked after you. We've had some really great weather. It's like the wind is a character all on its own. I've seen some of the hairstyles that have come out when people coming in from the parking lot. It's like, that's part of who we are here. So it's such a pleasure to have had you here. Anyway, I appreciate your not wanting to listen to me. You would like for me to introduce the Honorable Len Marchand. I can tell you with great certainty that this is a man who brings honor to this profession. He brings the dignity to the rule of law that it deserves. He hired me. He hired me when I was a law student to work the night shift with the janitors, which I really appreciated. I got to work on some residential files. He was also one of the only lawyers in town that would invite us to have pizza at his very fancy firm, and it felt very fancy going into the boardroom. So I have lots of things that I could say about him, but one of the things that I wanted to do, I wanted to say kind of a funny joke, but I wasn't sure if it was going to get me disbarred or not. So I had to get some legal counsel ahead of time. And then I was able to talk to Chief Justice Marchand, and he confirmed that I was allowed to do what I felt was appropriate, which of course is open to interpretation, so we're back to the coyote. So I would like to introduce him, I would have liked to have introduced him as the Beyonce of the legal world in British Columbia. So, go.
I've been called a lot of things. I once had this So you get called Justice, my Lord. In the old days, Your Lordship, Your Honor. All of these polite things. I was called some not so polite things by people I had denied bail, and they're on their way back to the cells, and they'd call me something over their shoulder. But my favorite was the self-represented guy who came in, and when he took the stand, he looked at me and he said, "Well, Captain, it's like this." And not admiral, not general, not colonel, not even a dignified captain. To him, I was Captain, like Captain Crunch. So Beyonce sounds a bit better. Lemlumt Cookschem, Masi Cho, Miigwech. Welcome, everyone. And thank you for the kind introduction and for inviting me here. I'm really honored to be here in the traditional territory of the Secwépemc people who've been hosting me and my family for quite a long time. I'm really honored to be here tonight celebrating the Moot, including the organizers, the hosts, the coaches, the facilitators, and especially all of you Mooters. Your focus on learning, collaboration, and understanding diverse legal perspectives represents a quantum shift from the historic competitive moots that I was familiar with when I was a law student. And it ties into my topic tonight, which is access to justice. As I hope will become evident from my remarks, in times of transition, taking different approaches will be essential to ensuring that we have a justice system that functions for everyone. From my vantage point, the justice system, like the rest of the world, is at an inflection point. Its AI is emerging as an ostensible rival to sound legal advice. Misinformation and disinformation spread freely. Our institutions seem to be under attack from all angles. Hard-won victories to level playing fields are at risk. Public resources are limited and spread thin, perhaps too thin. In the justice system, these threats and others have real implications for access to justice. In my new role as Chief Justice, I've been thinking about access to justice a lot. In particular, I've been thinking about three groups of people who have or who create access to justice issues. The first group is the group of people who are so marginalized that they don't turn to the justice system to address the issues that they're facing, even when they should. The second group is the group of people who would like to access the justice system but can't, either at all or fully, because of seemingly insurmountable barriers like complexity, cost, and delay. The third group is the group of people who use way more than their fair share of scarce public resources to resolve their disputes, which has the effect of denying other worthy parties the court time that they need and deserve to resolve their pressing legal disputes. Tonight I'm going to speak with you about our collective obligation in these times of challenge, change, and transition to do our parts to not just preserve, but to advance access to justice. I'm going to do that by sharing a few thoughts about the issues facing or created by each of the groups of people that I mentioned, the disconnected, the precluded, and the folks who use more than their share. I'll then suggest some things that you can do to address the issues, and I'll conclude by calling on you to do your part. So let's talk about transitions. I've been through a lot of transitions in my professional life. When I was growing up, I was pretty good in chemistry, math, and physics, so I dreamed of becoming an engineer, not a lawyer, and certainly not a judge. After completing a degree in chemical engineering, I worked in the oil industry for 5 years until I realized that I was not finding the corporate mission of maximizing return to our shareholders to be sort of personally fulfilling. And rather idealistically, which I hope is something that you share, I settled on attending law school because I wanted to help people and make a difference in their lives. I finished up at UVic Law in 1994, then articled and practiced here in Kamloops. And although I had a varied litigation practice that included working for institutional clients like banks and insurance companies and local governments and a crown corporation, I eventually dedicated my entire practice to assisting residential school survivors. As that work was winding down, I submitted an application to serve on the provincial court. After almost 4 years on that court, I was appointed to the Supreme Court, and then to the Court of Appeal, and then to my current position. And I would say to you that that is a lot of transitions. And each came with its share of new challenges. I want to tell you about my first big decision as a Supreme Court judge. I remember it really well. I was called by the minister's office. That was Jody Wilson-Raybould's office, our first Indigenous Justice Minister, to inform me of my appointment to the BC Supreme Court on National Indigenous Peoples Day, June 21st, 2017. It was a Wednesday evening. The public announcement was made 2 days later on the Friday. On the following Monday, I was in Vancouver being sworn in by Chief Justice Hinkson. Because I'd had close to 4 years experience judging, I was assigned a 4-day trial starting the next morning. It was a commercial case involving some relatively high-profile litigants and senior counsel. We were assigned courtroom 11 at the Vancouver Law Courts, which was a bit hard to find in the labyrinth that's the secure side of that courthouse. My court clerk very diligently throughout the day came to my chambers, walked me to and from the courtroom, and she did that for a couple of days before I confidently told her, I got this. At the morning break of the third day of the trial, I made my way from courtroom 11 back to my chambers successfully, and after the break, I confidently walked back to the bank of elevators that took me to courtroom 11. When I got off the elevator, I realized I'd taken the wrong one. But fortunately, I saw this sign with an arrow directing me to courtroom 11. So I followed the sign and others down the hall and out a door. And as the door closed and locked behind me, I realized that I was in the public foyer outside of courtroom 11. So my first big decision as a Supreme Court judge: do I walk through the public area of the courthouse, find my way back to the secure side, get to that elevator that I didn't take, get back down and get into the courtroom that way? Or do I just walk into the courtroom from the foyer? So what the heck, I decided on the latter. And when I walked in from the back of the courtroom, those senior lawyers just jumped to their feet. They didn't know what to say. They were really surprised. But they were not as surprised as the poor court clerk when I came out of the courtroom to the secure side to tell her that I was ready to proceed. But, in all seriousness, I see inflection points and times of transition as providing opportunities to make positive changes. So let's talk about the opportunities of the here and now and how each of us has a role to play in tipping the scales of justice in favor of access to justice. And let's start with the folks who are so marginalized and disconnected that they don't turn to the justice system when they should. So let's talk about the disconnected. My views about disconnection are informed by my experiences as an Indigenous person and my work with and for Indigenous people. It's no big secret that Indigenous people in Canada come into conflict with the law in negative ways in grossly disproportionate numbers. In particular, incarceration and child apprehension rates are astronomically higher for Indigenous people than for other people in Canada. Yet in other areas, Indigenous people with a legal issue don't turn to the justice system for help. The reasons for both of these phenomena are deeply rooted in our colonial history of exclusion, mistreatment, and discrimination. Many Indigenous people see an adversarial justice system focused on correction and punishment that doesn't reflect their histories, cultures, customs, and values. Many have historically experienced a system that's unjust and unfair, where they don't feel respected or understood, and where they usually lose. And as a result, even though we've taken a number of very positive steps within the justice system, Indigenous people are less likely to exercise their rights or participate as a complainant, as a witness, or as a juror. Like, why bother? For example, why would an Indigenous person think to turn to a human rights tribunal when it's sort of normal to face discrimination? Why would an Indigenous person file a criminal complaint when they don't expect to be treated with respect? Why would an Indigenous witness attend court when they don't expect to be believed? And why would an Indigenous person show up to serve on a jury when they, their families, and their communities have not had good experiences in the justice system? The result is greater isolation, division, and conflict, which isn't in anyone's interest. As we know, there are other structurally disadvantaged groups who also do not turn to the justice system because they too do not view it as just. Clearly, we have some heavy lifting to do to demonstrate that we have a justice system that's for everyone. Let's talk about the precluded. I'd like to think that everyone in this room shares a common understanding that the justice system is meant to play an essential role in preserving all that's good in our society and improving all that's not good. I also hope that we all understand the ability of the justice system to deliver on its promise turns on public trust and confidence in the system. Plainly, high costs, significant delays, increasing complexity of legal proceedings hurt everyone. By creating barriers to access to justice, they diminish public confidence in the justice system, damage the rule of law, undermine substantive results, and risk the privatization of the civil justice system. The courts, governments, and the bar have all focused deserved attention on reducing barriers as a means to increase access to justice. And we certainly can take pride in our successes. And to give just a few examples, the courts have simplified rules and forms, made good use of technology, increased the use of case management increased the use of case management, and endeavored to provide streamlined processes for suitable cases. The Human Rights Tribunal here in BC is transforming itself to remove barriers facing Indigenous complainants. The provincial government has recently announced increased legal aid funding for women facing family violence. The federal government has a lot of catching up to do, but has indicated that filling judicial vacancies across the country is a top priority. And many members of the bar work in the not-for-profit sector or provide pro bono or low bono services to folks who lack the human or financial capacity to advance worthy legal causes. But clearly, again, we have more to do. What about the folks who use more than their share? Everyone who's worked in the justice system for any length of time has been frustrated by parties who use far more than their fair share of scarce judicial and court resources. They drive up the cost of litigation and prevent others from having their cases heard. Dealing with folks we identify as vexatious litigants can be particularly difficult. It takes a lot of time, effort, and patience to ultimately establish that a party is not just litigious, but vexatious. Once that's been done, the courts can make orders to control which of a vexatious litigant's matters, if any, get court attention. But leaving vexatious litigants aside, over the years I've witnessed lots of other examples of parties using more than their share of scarce resources with no apparent regard for the impact their proceeding has on others and the justice system as a whole. Of course, there are complex cases that need and deserve plenty of court time. Complex criminal prosecutions, high-stakes commercial litigation, and Indigenous rights and title cases are examples that come immediately to mind. The cases that concern me, though, are the ones where not only is the litigation gobbling up scarce judicial and court resources, but it also appears to be counterproductive in the sense of being completely out of proportion to what's at stake. For example, the courts are full of cases where there's a fixed amount at issue, for example, in family, estate, bankruptcy, and certain kinds of commercial cases. In these cases and others, every dollar spent on legal proceedings is a dollar less that will be available to the parties at the end of the day. Along these lines, Indigenous communities are advancing very important court cases. As future lawyers, you Mooters will have to carefully assess risk and remember that every dollar spent on legal proceedings could be a dollar less that the community has available for other important programs and services to community members. In any event, when cases take on a life of their own, usually no one's interests are served. When I see these cases, I do resist pointing the finger at counsel because, of course, it's the client who's giving the instructions, but sometimes I can't help but wonder about the conversations that counsel had with their client, or perhaps the conversations that they should have had but didn't. So what can we do? It's not so hard to identify the issues. It's always harder to find the solutions. But let me share with you a few thoughts. I'll start with the disconnected and focus on an area that I and some of you know best, namely the plight of Indigenous people in Canada. And by choosing this focus, I don't intend to minimize the circumstances of other structurally disadvantaged groups. How can we make the justice system more welcoming to the folks who are so disconnected that they don't look to it when they should? So here's an example to demonstrate what's possible. I began working for residential school survivors in the late 1990s. At the time, standard civil litigation was the only real recourse that was available. So I worked very hard to advance claims against Canada and churches in a timely way. I traveled to my clients' communities. I really got to know them. I interviewed them extensively before drafting pleadings. I gathered and reviewed all sorts of documents about them and the schools they'd attended, and helped my clients respond to very lengthy interrogatories, and eventually I got them ready for discoveries. And I should say that Christy mentioned all of this work was supported by tremendous teammates, two of whom are in the audience, not just Christy, but also Alana Hughes, who's here as well. She was a really valued teammate of mine. So typically, my clients were, if I can be frank, they were shredded by the litigation process, especially by the discovery process. Despite testifying with honesty, dignity, and integrity, they often felt disbelieved and disrespected. Nothing personal against the lawyers who were asking the questions, but I often felt the same. The questioning was always very polite, but it was obvious that some of the lawyers asking the questions were from a different world and just did not believe what they were hearing. And I don't blame them. Like, what person from their background and life experience could believe the hideous things that happened to the Indigenous children who attended Indian residential schools? But to make matters worse, it was obvious from common lines of questioning that Canada and the churches were gathering evidence to ultimately argue that survivors would have had all sorts of struggle in their lives, even if they'd not been abused at residential schools. In other words, as Indigenous people in Canada, life was going to be pretty crappy for them anyway. It was hard for my clients to understand why Canada and the churches tried to blame the hardships that they'd endured after residential school on other negative experiences that they had within their families, within their communities, and just generally within Canadian society. They thought their discoveries were supposed to help Canada and the churches understand what they'd gone through and how that had affected them. Canada and Indigenous people, as we know, have a forever relationship. And sadly, the litigation experience of survivors was only driving an even bigger wedge between them. Not good. Early on, I knew there had to be a better way, and fortunately, I was not alone. To its credit, Canada invited me, like-minded claimants council, and churches to work with them to find a more proportionate, supportive, and less adversarial way to resolve the claims of survivors. And that's something that I'd like to think we eventually achieve with the independent assessment process, or IEP, that was created as part of the Indian Residential School Settlement Agreement that was signed in 2005. The IEP wasn't perfect, but the support, respect, treatment, apologies, compensation, recognition, and validation that survivors received established the IEP as a trustworthy place to turn for justice. As a result of creating a credible process, over 30,000 survivors advanced claims within the IEP, with the vast majority being validated by independent adjudicators. And these numbers absolutely smashed the expectations of the parties who negotiated the settlement agreement and demonstrated, to my way of thinking, what's possible when justice is done right. Looking forward, the Truth and Reconciliation Commission's calls to action provide a number of concrete steps that we can take to achieve the type of transformative changes that are necessary to right past wrongs and connect or reconnect us all in good ways. Ironically, the greatest number of calls to action are in the areas of education and law. And I say ironically because education and law were the primary tools of oppression, but the TRC saw them as holding the most promise for the future. TRC Call to Action 27 calls on the Federation of Law Societies of Canada to ensure that lawyers receive appropriate cultural competency training, which includes the history and legacy of residential schools, the United Nations Declaration on the Rights of Indigenous Peoples, treaties and Aboriginal rights, Indigenous law, and Aboriginal Crown relations. This will require, I'm quoting, this will require skills-based training in intercultural competency, conflict resolution, human rights, and anti-racism. As you probably know, Call to Action 28 calls on law schools in Canada to require all law students to take a course in Aboriginal people in the law covering these same topics. More than 10 years after its release, the TRC's report and calls to action remain relevant and critically important. That said, I have to say that I only but do not love the term cultural competence. I like the term cultural competence in the sense that it promotes the ideal of providing culturally informed and culturally appropriate legal services, but to me the term also suggests that there's an endpoint to understanding and that it's possible to master someone else's culture. And it can lead to one-size-fits-all stereotypical thinking. I prefer the term cultural humility because it encourages us all to be open to listening and learning, to recognize that we can never be fully competent in someone else's culture, and to understand that we have an ongoing duty to develop the skills we need to connect with those who are different from us. For the future lawyers in the room, it goes to the core of being able to connect with clients and respond to their individual legal needs, regardless of differences in backgrounds. Happily, Call to Action 27 has been addressed to some degree. Here in BC, the Law Society of British Columbia has mandated online cultural competency training for lawyers. I also see the obligation to work towards cultural competence and every lawyer's ethical obligation not to discriminate against colleagues, employees, clients, or any other person. Regarding Call to Action 28, my understanding is that law schools across Canada have gone much further than the TRC envisioned, and hats off to the law schools across the country. Forgive me for stating the obvious, but properly trained and culturally competent lawyers will help their Indigenous clients achieve better legal and human outcomes. Perhaps less obvious, but in my experience equally true, properly trained and culturally competent lawyers will achieve better outcomes for their non-Indigenous clients as well. I say this because properly trained and culturally competent and culturally informed, culturally sensitive, culturally humble lawyers are the kind of lawyers who will be aware of a greater range of possible solutions and may be able to find a more creative and superior solution to the problems facing their non-Indigenous clients. These types of lawyers will be better able to avoid conflict and find a more cost-effective and perhaps more restorative solution for everyone involved. In other words, the skills that you Mooters have developed through your participation in this Moot will apply broadly to your work as lawyers, no matter your area of practice and no matter who you're acting for. Cultural competence is not only a necessity for ensuring ethical practice, but over time it breeds inclusivity. It works towards a sense that the justice system belongs to everyone. Along these lines, one important step that you can take is to press your future firms or organizations to adopt an equity, diversity, and inclusion policy if they don't already have one. It's really important to ensure that we have all kinds of different faces in all kinds of different spaces in all kinds of different places. And as you know, a proper EDI policy must go beyond taking steps to merely look different. It will ensure that the firm or organization will actually be different by listening and learning as they meaningfully incorporate the insights and input of others. In this way, the firm or organization will find the best solutions for their clients' legal issues. Next, let me share a few thoughts about both the folks who are effectively precluded from accessing the justice system and the folks who consume more than their share of scarce resources. The concerns and the solutions for these groups overlap. The key concept here is proportionality. And proportionality can't mean that the more dough your client has or the more dough that's at stake, the more court time they get. Proportionality has to also come with a good measure of rationality. Your clients want, need, and deserve your help in pursuing the most time and cost-effective process to resolve their legal disputes. Of course, they also want, need, and deserve your diligence and honesty, including your honest advice about accepting a reasonable settlement. Sometimes clients and lawyers lean towards lengthier civil proceedings, driving up costs and forcing the other party to abandon their claim or accept an unreasonable settlement. Cost and delay become weapons in a war of attrition. Such tactics not only get in the way of access to justice, but undermine public trust in the justice system. There are also other ways in which increasing complexity, cost, and delays can overlap, namely, as I've mentioned, the use of scarce and publicly funded judicial and court resources. Courts are limited in the number of judges, courtrooms, and staff that they have available. As you're likely all aware, judges, sheriffs, and other court staff are currently in short supply in many courts across the country. For access to justice and public trust in the justice system to be maximized, you future lawyers will need to be judicious about how much time you really need to fairly try your cases. So let's talk about some takeaways. When I think about the justice system, I can't help but think about how it sits at a point of inflection. Each of us has choices to make that can have long-term effects on costs, delays, and trust in the legal system. With such high stakes, it's not enough to hope for better. We, all of us, need to be and do better. So let's be cognizant of the harms to the justice system and society as a whole that flow from insensitivity, exclusion, conflict, cost, and delay. Let's be open to using all available means to minimize these drags on the justice system. Let's continue to use court resources efficiently by treating one another with courtesy, kindness, and respect, reducing pretrial delay, focusing on the issues that matter, and refusing to enable complacency or unreasonableness from our clients. Let's stay up to date on new technology and best practices, and let's ensure that our firms and organizations commit to practicing cultural humility and to continuously improving cultural competency. Returning to my personal story for a moment, I'd like to think that the experiences that I've had as an Indigenous person in Canada helped me perform my duties well, not just for Indigenous people, but for all people. No one, least of me, is perfect, but I do my best to listen carefully and respectfully, to empathize, to be fair, to be timely, to look for restorative solutions whenever possible, to make the hard decisions whenever necessary, and to express myself in accessible language that the parties can understand. I hope that these sorts of small steps help build public trust in the justice system in a way that can advance access to justice. Obviously, we can't rewind the clock and correct past mistakes, but can we be and do better? Can we be mindful of the role our choices play in the lives and interests of others? Can we learn from past mistakes and make every effort not to repeat them? As we face points of inflection in the coming days, weeks, months, and years, I believe we can. Though some big changes may be necessary, it's mostly going to be this sort of brick by brick, step by step, person by person, family by family, community by community process. In these times of, I guess it's a way of saying that small steps matter. In these times of transition, lawyers will continue to be central players. As has already been mentioned, you can be agents of change. Together and individually, you have the ability to tip the scales of justice in a positive direction, towards progress, towards inclusion, towards access to justice, and towards reconciliation. So please, let's all do our part. Lemlamd.
Thank you very much for that fantastic keynote, Chief Justice Marchand. So now we are going to transition into some entertainment. It'll take a couple moments to clear the stage. We have a group called the All My Relations Dancers coming in, and then once they're done their performance, I think we'll start to head towards winding down the evening with a couple more speakers to come up and a couple more thank yous to give. So we're going to take a brief pause here while the dancers come in and start to get ready. Thank you.
Dear guests, I'm honored to close this banquet with gratitude. First, I want to acknowledge Justice Marchand for being the keynote speaker here tonight. Justice Marchand is from Kamloops, and his work as a lawyer stands as a testimony to the transformative power of the law and how it can and should be used to address injustice. Thanks to you, Justice Marchand, for being such a firm supporter of TRU law and the work we do. To all the schools and students, thank you for having traveled to Kamloops to participate in this moot. We enjoyed hosting you, and we hope we'll be able to do this again. To all our moot coaches, some of you are employees of universities you represent, and some are volunteers offering up your time and expertise to help us as legal educators to teach. Learning by doing is a crucial part of the journey of every law student. To our facilitators, you have shared your expertise, you have set aside valuable time, and you have stepped up in a meaningful way to facilitate the negotiations. It means so much to us and our students. To all our sponsors, our platinum sponsors are OKT and the BC First Nations Justice Council. Our gold sponsors are Stewart and Springford Lawyers, Radcliffe LLP, Clio, First Peoples Law, and CN Indigenous Relations. Thanks also to our silver sponsors, Forward Law LLP, Dawson Truck Centres, Miller Tartalel and Company, Terra Timber Incorporated, RJ Tour Personal Estate Corporation, Remax Real Estate Kamloops, and Woodward and Company Lawyers LLP. We simply would not have been able to do this without you. Your investment in Indigenous legal education is highly appreciated. To our Advancement Office, Sarah, thanks for your work with our sponsorships. In my own office, thanks to Cara for all the work behind the scenes to support with catering, printing, logistics, and the beautiful flowers on the table. She was supported throughout by Lisa Grant. To our Assistant Dean, Lana Walker, there was not a curveball that you did not play this week, and I appreciate this so very much. To our organizing committee, I want to thank Professor Bradford Morse, former Dean of TRU and pioneer of Indigenous legal education at TRU, Christy Stewart, alum and special advisor, Miranda Seymour, senior lawyer and TRU alum, Ben Turner, 2023 alum, and firm supporter of TRU law, and Rob Hould, third-year student and master of ceremonies. Then we also had Taylor Pittendrake, first-year law student, and Orson Ferguson, the multi-talented dynamo who supported all of us through this week. Thank you also to Brendan Semchuk, Noah Huston, and Adam Tour. And last but not least, my sincerest thanks to Marie Schulte and Gabriela. Behind every man, there is a strong woman. Gabi, muchas gracias, mi amiga. Eres una mujer excepcional. Marie, you have outdone yourself. You have interjected this faculty with a bolt of energy. We could not have done this without you. Here's to many more meaningful and auspicious occasions at TRU Law.
Hello, everyone. Waikhohuaytip in Samastinen Squaus, Bernice Jensen, Cooksjachumk. Hello, everyone. I'm Bernice Jensen. We are All My Relations First Nations dance group based out of Kamloops and the Okanagan and Vernon. Just like the name implies, we are all related to each other. We are sisters, children, nieces, and nephews. So tonight we're here to do a dance performance for all of you wonderful people. Cook's Jam to the Department of Law for inviting us, and Moot for inviting us here tonight, and I hope you enjoy it. So our first performance is going to be with Stéphane Richard. He's going to be dancing grass dance. So with the grass dance comes from the prairies. It's for the young men would go out, and when the villages would move from area to area, the men would go out ahead of the group, and they would dance around to bless the ground. But they also were patting down all the grasses as well, because some of it could be up to the knees. So they'd go around and they'd stomp down the grass, bless the area, and so this is our grass dancer. He is the one that usually starts off at a powwow, and they will bless the grounds. Cook's Jam. So that is my nephew, Stéphane Richard from Vernon. He dances also chicken, but tonight he was doing grass dance. So, Stéphane. So our next dancer is my daughter, Jewel Jensen. She's Okanagan and Kamloops as well. She's going to be dancing jingle dress. Jingle dress dance comes from the Anishinaabe people. It was told that there was a story of a young girl that was very sick, and while she was sick, her grandfather had a dream that he was to make a dress, and the dress would have these cones, and when the cones would jingle, it would send the blessings to the Creator, and it would offer up prayers to the young girl. And so when the grandfather made the dress, the girl wore the dress, and she was healed. So we always call this one as well, they say it's the jingle dress, but it's also the healing dance as well. So thank you. Okay, yeah. So that was Jewel Jensen and my daughter. Next we have Seth. So Seth is also from the Okanagan Nation. He is doing the chicken dance. The chicken dance is also from the prairies. And so from the prairies, they imitate the prairie chicken, sorry, my mind went blank. They imitate the prairie chicken, and it's the male prairie chicken that is dancing and is trying to attract the female, and so he is going to do his best job to get the female's attentions. So he is the prairie chicken, and he dances, he's been dancing for how many years, Seth? For about? Ever since I could walk. Since he could walk. So, yep, so this is Seth and Cook's Jam.
Before we start, we need to get lively, people. We need to know that you're out there. We need to know that you like what you see on the dance floor. Make some noise. Ladies and gentlemen, make some noise. Go on, here we go.
Okay, so that was Seth, our nephew. Next we have the women's traditional. So, and we're also, my sister's telling me we're also golden age. So we are all grandmothers or mothers and grandmothers, and so we are dancing golden age. And so my sister Sue here, my sister Bernie, and then again I'm Bernice, and we go and we travel all around Indian country and we dance. We also work full time, so when we get a chance, we'll hit the powwows. We'll go to Washington, Idaho, Montana, Alberta, and BC. So we travel around a bit. We also like to do performances like tonight. So thank you to TRU, to the law faculty for inviting us, and to Marie. And so we really like to come out and put on a show. So hope you enjoy it so far. So Cook's Jam. So that is golden age. And so normally at the powwows, people will rise for the golden age because we have reached that age in our lives where you honor the elders, so to speak. And so we didn't mention that, but that was okay. So, but that's what they typically like to do. So our next person is my other son. Some of you were able to meet him at the opening ceremonies yesterday morning. Junior Jensen. Dad is Tim Jensen, and they're from the Kamloops First Nations band here in Kamloops here. So Junior is dancing traditional. Again, traditional dancers all had their own dance category. This one's kind of from the plains as well. And so as you can see, he's got the buffalo hat, he has the eagle feather, he has his beaded vest and side drops. So he's been dancing since when I was expecting him. So he's been dancing since before he was even born. He was dancing with me. So this is Junior. He's dancing traditional. Cook's Jam.
Here we go, sharpshooter. Thank you very much.
Okay, so we have danced all the different dance categories, but I just wanted to acknowledge the Honorable Len Marchand Jr. I haven't met Len, so could you? Oh, there we are. Okay, so Len comes from our reserve in the Okanagan. His dad grew up in the Okanagan. Our family comes from the Okanagan. We're Marchands as well from the Okanagan. We're part of the Marchand family. So it's nice to meet you. So thank you for the invite today, and thank you, Honorable Len Marchand Jr. It's nice to meet you. And we're going to do a final song. It's a kind of like a grand entry, but it's going to be the exit instead. So instead of the entry, we're ending it. So we do it and when we retire the flag. So we'll do this one last time. They're going to come across the stage, come down, and that will be our dance performance. So thank you so much, everyone. Again, thank you to Marie, to TRU law faculty, and to all of you for sticking around and being here with us. So Cook's Jam.
Minneapolis, Minnesota.